Let your verdict give us the answer.
As a nation, we will never forget December 16th, 2012. It is a date that is indelibly etched into our collective memory. The horrific and brutal gang rape of a 23-year-old woman left the country stunned and outraged, and once again brought attention to one of India's most devastating problems: violence against women brought about by deep-rooted sexist, misogynistic, and patriarchal attitudes. But here's a question. Do you remember the name of the victim? Most of us know her by the names given to her by the media: Nirbhaya, Damini, Amanat. But last year, exactly 3 years after the incident, the victim's mother publicly revealed her name, Jyoti Singh. 3 years earlier, the Delhi police had filed an FIR against reporters of the tabloid Mail Today for revealing the identity of the victim. Under Section 228A of the Indian Penal Code 1860, printing or publishing the name of a rape victim without the permission of the victim, or in case the victim is dead, the permission of her next of kin, is against the law. This section was put into the IPC by a Criminal Amendment Act of 1983 that, like the reforms of 2013, also brought about massive changes to the laws relating to rape. And like the 2013 amendments, the 1983 Act was the result of a horrific incident that took the nation by storm. It is known as the Mathura rape case, and it was perhaps the first case that truly got the whole of India thinking about our laws on sexual violence against women. Let's take a brief look at the facts. The year was 1972. Mathura, a young tribal girl between 14 and 16 years of age, lived in a small village called Desaiganj in Maharashtra with her brother Gama. Both Mathura and Gama were labourers, and Mathura used to go to the house of a woman called Nunshi for work. Nunshi's nephew Ashok also lived in the same house, and over time Mathura and Ashok fell in love with each other and decided to get married. However, Gama disapproved of their relationship, and on March 26, 1972, he lodged a report at the Desaiganj police station alleging that Nunshi and Ashok had kidnapped Mathura. Nunshi, Ashok, Gama, and Mathura were brought to the police station at 9 p.m, and the statements of the lovers were recorded. At around 10:30 p.m, when they were about to exit the police station, constables Ganpat and Tukaram told Mathura to stay back and asked the rest to leave. While Gama, Nunshi, and Ashok were waiting outside, Constable Ganpat locked the door, turned off the lights, and raped Mathura. Constable Tukaram also tried to rape her but was too drunk to do so. Sensing something was wrong, Nunshi, Gama, and Ashok called out to Mathura from outside but heard no response. Finally, when the deed was done and the constables had fled, Mathura emerged from the police station where a crowd had now gathered and told Nunshi, Gama, and Ashok what had happened. The crowd threatened to burn the police station unless the head constable filed an FIR. However, in a judgment many of us would find shocking today, the Sessions judge acquitted both the constables.
I continue to be shocked at the language of the judgment. So the Sessions Court dismissed Mathura as a shocking liar whose testimony is riddled with falsehood and improbabilities, and that it came to the conclusion that she had sexual intercourse at the police station. She was habituated to sexual intercourse and found that her fiancé or her husband was angry with her, and that's how she wanted to sound virtuous.
The Bombay High Court, however, reversed the Sessions Court judgment and found the constables guilty. It noted the difference between consent and passive submission, observing that mere passive or helpless surrender of the body and its resignation to the other's lust induced by threats or fear cannot be equated with the desire or will. But when this judgment was appealed, the Supreme Court reversed it and acquitted the constables once again.
And the Supreme Court came to the conclusion that there were no marks of injuries found on the person of the girl after the incident, and their absence goes a long way to indicate that the alleged intercourse was a peaceful affair, and that the story of a stiff resistance having been put up by her is all false. And they've come to the conclusion that her allegations against the two police officers were completely untruthful, that because there were no injuries on her, because she did not scream, because the whole incident, according to the Supreme Court, was too fanciful. It could not be believed.
What could lead learned judges of the Supreme Court to give such an extraordinary judgment? To understand this, we need to recognize the prevalent mindset that existed in our judiciary and society in general at that time. It is a mindset that to a large extent still exists today.
When you look at criminal law, IPC, the legitimate space to have sex and heterosexual sex is within the sphere of marriage. If you do it any other place, then you are a person of questionable character, for women, not for men. And therefore, if you were having sex with somebody else without marriage, you are a loose moral character woman, and the construction of women is that they are in any case looking for, no, they don't worry about all that. And also I think the definition itself provided that scope for the judges to do that. When you had these two clauses, one which says, and those clauses still continue. The first clause says sexual intercourse by a man with a woman against her will. The second one says without her consent, which categorically push the first burden, you must resist. If you do not resist, you've consented, then we will into the question whether the consent is valid or not. So any woman who did not consent, did not resist, did not suffer any physical injury in the process of being raped, then she was a suspect category.
The Supreme Court's judgment in the case was delivered on September 15, 1978 and was reported in 1979. Although it went largely unnoticed at the time, it caught the attention of Dr. Upendra Bakshi. Dr. Bakshi would of course go on to become one of India's most renowned modern jurists and the recipient of the Padma Shri. But at that time, he was a professor at the Faculty of Law, University of Delhi. Needless to say, when Professor Bakshi read the Mathura rape case judgment, he was appalled.
And I was quite shocked and quite enraged by the decision. I thought long and hard, spent many a sleepless night, till I hit on the idea of writing an open letter to the Chief Justice of India.
Professor Bakshi drafted the open letter and then began to look for people who would sign it. But neither his fellow professors nor his students were willing to do so. Criticizing the courts, making them accountable to people, was completely unheard of.
The first person to support me, in a sense, she would sign, was Latika Sarkar. And God bless her for that, because she knew a lot of criminal law. She, in fact, taught penal code.
And Professor Sarkar certainly had done her that Status of Women study in 1974. Professor Sarkar again wasn't a feminist before that study, and she had a very standard household where she was the wife along with being whoever else. But I think during that period she also realized, and she used to share us instances that how she had to gradually re-establish her equation with her husband in her own house.
I then reached Vasudha, who was teaching in Pune, and she's an activist. She wasn't, she just passed away recently.
Vasudha Dhagambar was in feminist studies. She had been looking at that perspective, looking at law from that perspective.
So she came on board, and then there was a bit of a struggle to get another teacher, Raghunath Kelka, who had just done with my help under my provocation, a great provocation, but he did the book ultimately called Criminal Procedure Code, which is a classic in its own sense. But the idea open letter, our open letter was very, very new.
And I said, I do not know what the consequence will be. It might actually turn out to be, maybe the court will take it as a court of contempt of court. So we might end up in jail, but we are clear that this is what we want to do.
Some of the observations they made were extraordinary, and back in 1979 for them to make that observation, which is relevant even today, and they're saying, Your Lordships, this is an extraordinary decision sacrificing human rights of women under the law and the Constitution. The court has provided no cogent analysis as to why the factors which weighed with the High Court were insufficient to justify the conviction of rape. It also highlighted the fact that courts often have one set of standards when it's dealing with the rich and the powerful, and have completely different standards while dealing with poor, tribal, vulnerable persons. And this letter says, My Lord, the ink is hardly dry on the decision in Nandini Satpathy when the Supreme Court, speaking through Justice Krishna Iyer, condemned the practice of calling women to police stations in gross violations of Section 160 of the Code of Criminal Procedure. And here was a woman who was raped within the confines of a police station. So the difference in approach was stark. And it was highlighted in this letter. It was also highlighted that while you set up constitution benches to look into the rights of a Golaknath or His Holiness Keshwananda Bharati challenging the validity of the restriction on the right to property, there are no fundamental rights when it comes to young tribal women who are raped within the confines of a police station. So it was an extraordinary letter, and it actually set the tone for future interventions, for amendments in the law, for feminist interventions, and in many ways it paved the way for subsequent judgments of the Supreme Court, where the Supreme Court then began to say that the sole testimony of the prosecutrix was sufficient for conviction if it inspired confidence, where the Supreme Court consistently said you cannot condemn a woman. Treat the complainant as an injured witness. Do not treat her as an accomplice. And the minute you treat her as an accomplice, that's when the problems arise, and that's when you start making value judgments on her character. So I think this letter of September 16, 1979, written by Upendra Bakshi and the rest of them, is probably the single most important letter which has been written as an intervention, which has been written in India's judicial history.
It was the first time that legal academia had taken it upon itself to analyze the law and demand real change instead of expecting it from the judiciary, a revolutionary act. As the letter gained greater traction and women's movements around the country grew stronger, Professors Upendra Bakshi and Lotika Sarkar started working towards a change in legislation.
We prepared a law reform memorandum, how IPC evidence and CRPC should be reformed. We did a very thorough analysis of the rape law. Now our problem was how to make Parliament take it up. I went to various MPs, gave them the memorandum, literally hawked them, tried to explain what was there, and said, please take it up. A lot of women's organizations also gave memoranda inspired on the lines we had given or something else. So it was the pressure of movements, women's movements, and the authors of the open letter initiated it. That led to parliamentary reform.
Thanks to the dogged efforts of the signatories of the open letter and the nationwide women's movements, the Criminal Law Amendment Act 1983 was passed, bringing about a number of groundbreaking changes to the laws relating to rape in India. And what were these changes? In the IPC, prior to 1983, there were no provisions to protect the identity of the rape victim. The Amendment Act inserted Section 228A, which prescribes punishments for printing or publishing information about the identity of the rape victim without her consent. If the victim is a minor or deceased, consent of the next of kin has to be obtained. Secondly, the Amendment Act changed the definition of rape. Before 1983, Section 375 contained 5 descriptions of rape. The amendment added a 6th. Thirdly, it significantly altered the punishment for rape. Prior to 1983, Section 376 prescribed a blanket punishment of imprisonment for a term of up to 10 years and fine for any and all kinds of rape. The IPC did not prescribe any minimum period of imprisonment or recognize the possibility of aggravated cases of rape. In 1983, a mandatory minimum sentence of imprisonment for 7 years was introduced for rape. Further, certain aggravated cases of rape were listed, such as rape by a police officer of a woman in his custody, rape of a pregnant woman, and gang rape. A mandatory minimum sentence of imprisonment for 10 years was prescribed for such aggravated cases. The maximum term of imprisonment for rape was increased to a life sentence. A man who has raped his own wife, who is less than 15 years of age but not less than 12, was made punishable with an imprisonment for a term of up to 2 years. However, in every case, the courts were given the discretion to impose sentences that are lower than the minimums prescribed. The Amendment Act also added 4 specific instances that do not fall under any of the definitions of rape, but are unlawful nonetheless. In the CRPC before 1983, Section 327 stated simply that all criminal courts were to be open to the public unless the presiding judge or magistrate ordered otherwise in a specific case. However, The Amendment Act of 1983 inserted subsections 2 and 3 in section 327, stating that inquiry and trials in cases of rape under section 376 and unlawful intercourse under sections 376A through D of the IPC shall be conducted in camera. In other words, the public and press are not allowed to observe these cases, and printing and publishing any matter related to such proceedings without the court's permission is unlawful. And finally, in the Indian Evidence Act, before 1983, there was no presumption of the absence of consent in rape cases. The Amendment Act added section 114A, which states that in certain prosecutions of rape, such as rape by a police officer or public servant of a woman in his custody, if the woman claims she did not consent, the court will presume an absence of consent. Let's take a moment here to address something important. This presumption of absence of consent seems to have caused a kind of panic among people who claim that the rights of the accused are severely compromised in rape cases. However, this is not true.
These amendments are related to a particular category of rape offences. They do not have any application with respect to rapes committed between two individuals outside the custodial situation. 114A applies only to those specific category of cases where there is where the woman is seen to be at a particular disadvantage because of the circumstances under which she is raped. However, even where there is this presumption, let me say as a practitioner of law, every presumption is a rebuttable presumption. The rights of the accused do not get compromised. Even in cases under 376(2), the prosecution must lay the foundation of the offence. The case has to be proved. Once the prosecution discharges its onus, only then will the onus shift to the accused, where he then has to bring in some material to show that the offence was committed with her consent. Yes, the only thing which courts now, at least courts in Delhi and other cities like Delhi, look at is whether the woman is comfortable while she's giving her evidence, whether the kind of slamming which used to take place earlier, that more or less most session courts try and prevent that from happening. She's still subjected sometimes to brutal cross-examination. And in the end, this marshalling of evidence takes place. I think this panic is unnecessary. I think it is coloring the debate in a way which will only take the progress made with respect to rape law back.
So what kind of progress has been made? Where does the Mathura rape case stand in the history of laws relating to sexual violence in India? What is its legacy?
What this case gave us was an opening to talk about violence against women, sexual violence against women, how that violence must be viewed outside the patriarchal the framework, how we should address certain issues relating to women, how we should look at corroborative evidence, how we should look at the testimony of the survivor. These are things which were thrown up because of the Mathura decision. I think because it was so bizarre, a conversation started. Although Mathura herself got no justice, it started a process which culminated in the 2013 Act.
And I certainly think that the 2013 amendments are the latest examples of how women were not consulted in this whole conversation. We had Justice Verma committee and I did appear there, but this whole conversation was there about the title being changed and all that. So certainly there were all these concerns. And Verma committee did recommend gender neutral law. The ordinance which came did come as a gender neutral category. But then said again, we're back to man-woman offence and we are not wanting to take away the stereotypical images. We just believe this, you put people behind prison and everybody will be safe. What is happening in those prisons is nobody's concern. What is happening in education is nobody's concern. What dictates we give to the men who are posing the danger, that's not the concern. Women will be safe when they remain inside their pinjaras, in their cages, in their homes. Even though we know that homes are the most violent places for women. So I think the legacy of this one is that you can actually continue to examine and re-examine and re-evaluate and critically keep looking at that area and keep reminding ourselves that the journey which began there of critically examining the law, bringing women's perspective into the legal experience is not there.
So while Mathura's case was a landmark in the history of the movement for women's rights, in the 33 years since the historic amendments were enacted, not enough has changed in the lives of the majority of women in this country. There is an immense amount of work still to be done to achieve some semblance of gender equality. And 37 years after the writing of the open letter that caused a paradigm shift in the way we approach rape laws in this country, the sole surviving author has something important to tell us.
When you look at the reality on the ground, you feel that one requires many, many lives to combat this evil. One life is not enough. And you require not one letter, not one movement, but thousands of letters and thousands of movements. Thousands of, essentially, if India is said to be young, and it is young, then the young people's duty, passion, must be to cleanse Indian society and culture of this evil.
It started with a tribal girl from Maharashtra, became a mission for a handful of law professors, and eventually led to one of the biggest nationwide women's movements in the history of India. We tend to forget cases like Mathura's, relegating them to the annals of history, but it is important for us to remember and learn from them as a new generation takes over the cause and moves forward with it. We'll be back with more soon. Meanwhile, please share this video and subscribe to our channel.